Bill 1015. And after your testimony, hopefully we'll have a quorum in here, so we might pause to establish a quorum, but proceed when ready.
Good morning, Mr. Chair and member of the committee. For the record, I am State Senator Maggie Nurrenbern, representing the 17th Senatorial District, and I'm here to present Senate Bill 1015. I am going to be presenting on the committee sub this morning that you all should have. Senate Bill 1015 creates a legal process for courts to order assisted outpatient treatment for adults with serious mental illness who are unable to voluntarily engage in treatment and are at risk of deterioration, hospitalization, or harm. Assisted outpatient treatment is court-ordered mental health care provided in the community, not in a hospital. The goal is to help people stay stable and live safely in the community. This allows people to receive structured treatment in the community before they reach a crisis that leads to hospitalization, incarceration, or harm. Treatment may include case management, medication management, therapy or counseling, substance use treatment, crisis intervention, and help accessing housing, employment, and community support. The bill includes strong legal safeguards, including the individual's right to an attorney, the individual can appeal the decision, and the order lasts up to 2 years with court oversight. If the individual does not comply with treatment, the court may require evaluation at a community mental health center or order short-term hospitalization if necessary. Currently, the Department of Mental Health has a waitlist for beds in psychiatric hospitals. In February, there were 446 individuals who were ruled incompetent to stand trial waiting in jails without conviction. This bill will help prevent more Missourians from languishing in our jails and other hospital beds. Senate Bill 1015 creates a balanced court-supervised system to help individuals with severe mental illness receive treatment in the community while protecting their legal rights and prioritizing stability, safety, and recovery. We've got quite a few subject experts in the room who are able to testify in support of this bill and probably answer some more specific questions that you all may have, but at this time I'm happy to answer any of your questions. Thank you.
Any questions for the sponsor? Seeing none. For the witnesses, we're going to alternate for and against. The first two witnesses are going to have 5 minutes to present, and then all witnesses thereafter will get 3 minutes until we get to redundant testimony, and then we'll shrink it down to 1 minute. With that, we're going to introduce the first witness in support of Senate Bill 1015. Before you do your testimony, I'm going to establish a quorum briefly. Mr. Secretary, can you call the roll?
Senators Schroer. Here. Gregory 15. Brown 26. Berger. May. Roberts. Schnelting.
Having a quorum, we're going to now go back to the public testimony on Senate Bill 1015. Proceed when ready.
And good morning, Mr. Chair and committee members. My name is Mark Stiles, Jr. I'm a circuit judge in Jackson County, Missouri. It's a privilege and honor to be here, and thank you for the opportunity. And Senator Nurrenbern, thank you for the invitation. Years ago, I learned from my pastor that our communities learn from sharing our truths. And I'll share a little truth with you all today. My son is 22 years old, and he is diagnosed with schizophrenia. He's had 6 suicide attempts and 5 hospitalizations, 5 of those being in long-term psychiatric hospitals. In my role as circuit judge, and I have my lawyer here, and he told me that I need to make sure that I'm here in my individual capacity, but in my role as circuit judge, I have trained law enforcement, other judges at New Judges College, ongoing training for lawyers for the 12 years I've been on the bench on mental health law and psychiatric commitments. And the reason why I give my son's example is that he went through outpatient treatment, and that's what Senate Bill 1015 does. It provides an involuntary outpatient treatment for those individuals that don't quite meet the standard of inpatient hospitalizations and don't meet the standard of the guardianships. And we'll have someone talk about guardianships a little bit later. But there's a gap that's existing out there, and Senate Bill 1015 fixes that gap. Psychiatric hospitalizations are one end of the spectrum, guardianships on the other. Our mental health system, as you all know, and I think we heard the report, is just not working currently. It's flooded, and people are falling through the cracks. What we have are people that get mentally ill and they get sick and they need to be hospitalized, but they can't find a bed because that bed is filled with someone that's pretty dangerous, so they get sicker. The sicker they get, they commit a crime. Now when they commit a crime, they're in jail. Once they made it to jail, they're getting even sicker. There are no state hospital beds. And so because that person can't get the state hospital bed in jail, they're getting sicker and they're decompensating. And then they take a civil bed. And that cycle continues because we've got someone in the community that needs that civil bed for that hospitalization. What Senate Bill 1015 is provide that gap measure to allow the courts to supervise individuals that are struggling with mental illnesses in an outpatient process, and allows the court to use what we term the black robe effect, where the judge is an actual coach for this person going through this mental illness process, going through this treatment process to make sure that they manage this mental illness. As many of us know, mental illness is not curable. We can't cure it, but you can manage it. And that's what AOT, assisted outpatient treatment, does. This bill does that. It helps these individuals manage their illness so they can be better functioning in society. It's a change. It's a change to our current laws, and it's a change to what we're going to do. And I was talking to someone the other day, there's two things that we hate about the government. It's change and things staying the same. And so we've got to look at things and try to do things a little bit different, and that's what Senate Bill 1015 does. It allows this mechanism for us to go through that. I will open it up for if you all have any questions now or if you have any questions later, but that's kind of the parts I wanted to cover. And again, thank you all for your time today.
Well, Judge, thank you for being here, and thank you for your service to the state. I know being an attorney and hearing from judges the amount of harassment you sometimes have to go through and your crazy docket. So I appreciate all that you do. I do want to correct one thing, though. You said there's two things that we hate about government. There's a lot more that I hate about government, but I don't think we have enough time to let me filibuster that. With that, can you just briefly go over the substitute, the process of what this is going to look like?
Got it. And so in Jackson County, we did start a pilot program, and the pilot program was built to bring the partners together. And so other jurisdictions such as Ohio, New York, and Kentucky have already established programs like this. And when they started these programs, what they've seen is a tremendous reduction in incarcerations, a tremendous reduction in hospitalizations, in negative police interactions, as well as homelessness. And when you have those reductions, you're saving millions of dollars. So these jurisdictions that have started AOT are saving millions of dollars. So the structure of it is this, is that the petition is filed, and I know there are lawyers here, the petition is filed with the probate court, and the probate court will order this outpatient treatment service that goes usually from 6 months to a year span. During that time frame, the judge would decide with the treatment team of the individual to come back to court for supervision to see how they're doing with their outpatient services and their treatment. Hopefully that time that they're coming back to court is reduced as we get to that year time frame. That way that's showing that they're managing their mental illness and they're doing better in the community, with the end goal being a graduation from the program to be able to manage their mental illness back in the community. What's big difference between Senate Bill 1015 and the current mental health courts, that mental health courts are voluntary. A crime has usually been committed and they're voluntarily going through a program to have the crime dropped or reduced. AOT is not voluntary. The court is ordering them to go through these services, to do these things, and the punishment or the recourse for not following through is hospitalization. And so the goal is to get them to do this, but it is involuntarily compared to other treatment courts that our state already has.
Any further questions for the judge? Seeing none. Thank you for your time. Make sure your witness form is filled out, and we're going to go to those testifying against Senate Bill 1015. Seeing none. Any for informational purposes? Seeing none. We're going to go back to those in favor of Senate Bill 1015. Please come forward. You'll have 5 minutes, and then the rest of the witnesses will have 3.
Good morning, Mr. Chair, members of the committee. My name is John Killian. I serve as the public administrator in Jackson County, Missouri. That gives me the dubious honor of having the highest caseload in guardianships in the state, some 1,006 people today. I'm speaking in support of this bill. I feel that it will help both our help us serve the people that come under guardianship and also help prevent people that may come under guardianship. As you look at this bill, and as Judge Stiles had indicated, you'll see that it approaches treatment for folks with mental health issues at an earlier stage in their illness process. It varies from our current civil commitment system in that while the standard of proof is still the same, you still have to prove by a clear and convincing evidence that the person is in need, the criteria for that admission is different. So currently, to have someone involuntarily placed in the hospital, you would have to prove an imminent risk of danger to self or others. With the AOT provisions, we're able to have a different criteria that is more treatment-based and allows seeing a person in need, someone that we feel will benefit from treatment, someone who we can attach services to, and then order them into care in that manner. There's a theory in guardianship that is a little bit archaic at this point, and there was a thought back in the 90s that guardianship was actually a less restrictive alternative for folks than civil commitments. And the idea is that for me to place someone in a hospital involuntarily, I can do that on a best interest standard, as opposed to having clear and convincing evidence that they're in imminent danger to themselves or others. So it's a lower standard. It's quicker. It allows me to see someone in need, someone that's beginning to have symptoms of their mental illness, and then seek hospitalization. It doesn't work, and it doesn't work because we still are dependent on the hospital having a place for them. We're still dependent on the hospital's criteria for admission, and while I can get them to the door, I'm still depending on the hospital to evaluate them and decide whether or not they need care. This allows the hospital itself, it allows other petitioners like law enforcement, it allows guardians to see this person earlier and have a way of approaching treatment rather than waiting until they're fully decompensated and in full need of hospitalization. So I think by approaching treatment at a point upstream, if you will, by being able to catch people when they're beginning to have their mental health crises, as opposed to later in the process when they've decompensated multiple times, when their illness is in full effect on their lives, and they've lost their housing, they've lost their treatment, they've lost their jobs, and we're going to guardianship. We can help prevent the need for guardianship later down. My expectation is that the need for guardianship would be reduced, the pressure on law enforcement and other social services would be reduced, and all in all, we'll see better treatment outcomes for our clients. I guess the last thing I would mention just quickly is that you'll notice with this, there's not a funding ask. And we're not looking at new money that would be approached with this. We're looking at working within the systems that are already existing. You'll hear from other folks on that issue later on, but the idea is that if you have partner hospitals, you have partner community mental health centers, you have partner judiciary, you're able to work with the resources that are already in place, and what AOT does then is provides an umbrella for that coordination and the collaboration among those groups. So with that, I thank you for your time, and I'll welcome any questions you may have.
Any questions for the witness? Seeing none. Thank you again for taking time today to testify. We're going to move to those in favor of Senate Bill 1015. Next witness in support. Make sure you have your witness form filled out. You'll have 3 minutes. Begin when ready.
All right, good morning. Thank you to the chair and committee for the opportunity to be here. My name is Stephen Gray. I'm a licensed clinical social worker at University Health in Kansas City, Missouri. My role is as a program manager for hospital diversion, case management, and an emerging assertive community treatment case management. We deal with most often the highest utilizers of all the community services, emergency departments, police departments, jails, inpatient units. All the individuals we serve have a severe persistent mental illness, along with the condition anosognosia, which is basically the denial of their condition. So in this denial of the condition, it's really hard to get collaboration on treatment, putting the person at increasing levels of risk. The way that AOT has worked, we have been part of the pilot project that I think Judge Stiles mentioned, and we will do an assisted outpatient treatment plan that basically includes pretty simple, straightforward things for the client and the court and our treatment team to follow in collaboration. That would be medication adherence, attending the court dates, meeting with the treatment team on a regular basis, usually like 3 times a week, and then suggesting and offering placement opportunities if that's needed for the person to have success. And so this holds the person accountable to getting treatment before they are at an imminent level of risk, like while they're at this kind of like, what I always seem to think of as like this inevitable risk. It's not imminent, but it's inevitable and it's going that direction and everybody can see it, but we can't intervene until it's at this place of ultimate dangerousness. And so just to, like, it holds the client accountable, but also the treatment team accountable. We are going to court with the individual. If the individual refuses to go to court, we still show up at court. We provide a progress report. We are making sure the person comes in to get their injection. Usually that's the most effective way to hold this project together. And if they don't receive it, we're following up the next day and offering and like seeing if there's ways that we can work with the person, engage them, and do a good job of like bringing the person in as soon as possible. As far as like successes so far, we have like a small group of people that have met the current criteria, which is like basically getting a 21-day hold and then being almost at the point of getting a 90-day hold. But they can choose this outpatient treatment, assisted outpatient treatment in substitute. One individual that I've known for a decade had been chronically homeless or being kicked out of his parents' house consistently for 10 years, set his parents' couch on fire, all kinds of like activity, almost died twice within the 12 months before we got him into this AOT program.
While your time has expired, I'll give you a couple seconds to wrap up.
Sorry, so this individual now has an apartment, is on medications for 2 years now straight without any interruptions, has a driver's license, is exploring job opportunities, and is much more successful than I've ever seen them or could have predicted without this. Thank you.
Thank you. Are there any questions for the witness?
Yeah.
Seeing none. Okay. Going to the next witness in support of Senate Bill 1015, please come forward.
Good morning, Mr. Chair and committee, and thank you, Senator Nurrenbern, for having us. I appreciate the opportunity. My name is Amanda Tamayo O'Neill. I am here in support of Senate Bill 1015. I am currently the Chief Human Resource Officer of University Health in Kansas City, but my testimony stems from my experience as a licensed clinical social worker and now, and also an attorney previously. So I actually want to describe what assisted outpatient treatment is not. It's not a new law. We are working within the statute that exists. We are amending it and enhancing it to update it. It does not create new civil commitment standards or alter existing protection for individuals with severe mental illness. It offers a form of treatment that is consistent with the least restrictive environment requirement. It takes place in the individual's own community with resources that are already in place. It focuses on increasing patient contact with clinical services in the community. It's also not a statewide mandate. Under the current law, counties without an inpatient psychiatric unit are unable to even consider utilizing AOT. The bill provides opportunities for all the counties to take advantage of it or to put it in place if they should wish to do that. It also allows them to create the program to what is available specifically to resources and access to mental health in those communities. It also is not reinventing the wheel. We have a strong community mental health program in place. As you've heard before, we are just operating within that already existing system. It also allows us to utilize a court system that is already in place and the processes within that probate court. It's also not detention or involuntary commitment. The bill actually includes a specific statement that it is not outpatient detention, and no provisions relating to requirements for inpatient and outpatient detention shall apply. It's also not a change in the protection of due process rights of individuals with severe mental illness. It supports a meaningful judicial process in place to protect the individual's rights. It requires a mental health professional or other similar professional to file the petition for AOT. Currently, any adult in the community can do that. It also requires clear and convincing evidence for the finding that AOT is appropriate in issuing the order. And it does entitle the individuals to request or move for reexamination of the order for AOT.
While your time has expired, I'll give you a couple seconds to wrap up.
Yeah. As an attorney, I recognize the importance of due process and protection of an individual's rights, and I look forward to continuing to work with Senator Nurrenbern on any proposed revisions. Thank you.
Thank you for your time and testimony today. Is there any questions? Seeing none. Any other witnesses in support of Senate Bill 1015? Seeing none. Any last call for the opposition? Seeing none. Informational purposes. Senator, any closing remarks?
Just appreciate the committee's time this morning. Obviously, there are a lot of benefits to this proposed legislation. Ultimately, we want to see fewer psychiatric hospitalizations and ultimately reduce incarceration as well related to untreated mental illness. So thanks for the committee's time, and I would be happy to talk with any of you about this. I know it's a little bit complex, but I think it really could be a big win for our state and for people in our communities. Thank you.
Thank you. That'll conclude the public hearing on Senate Bill 1015. With that, since we have a quorum, I'm going to make a motion that we go into executive session. Do I have a second? Having a second, we're now in executive session. I'm going to move that we bring forth the substitute on Senate Bill 927. Do I have a second? Having a second, we are now on Senate Bill 927. I move that all those in favor signify by saying aye. Aye. All those opposed say no. The ayes have it. The bill is before the committee. Senate Bill 927 is one on the 7OH that Senator Nurrenbern presented several weeks ago. I want to applaud her for working towards an agreement with all of the parties, and we have a substitute that's been distributed to the committee a while back. I have a copy here, but it's also in your emails as well. Substitute is ending in .02C. Senate committee substitute makes several changes on the level of 7OH that is allowed to be sold, removes Section 196 in the introduced bill relating to the display of kratom products in the retail location. It's not necessarily as hard as Senator Henderson's bill, but this is working toward a compromise. Is there any discussion on the Senate committee substitute? Seeing none, I move to adopt the Senate committee substitute for Senate Bill 927. Do I have a second? Second. Having a second, all those in favor signify by saying aye. Aye. All those opposed say no, and the ayes have it. Senate committee substitute has been adopted. I move to do pass Senate committee substitute for Senate Bill 927. Do I have a second? Second. Having a second, Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Aye. Brown 26. Aye. Berger. Aye. May. Roberts. Schnelting. 5-0.
By a vote of 5-0, the Senate committee substitute for Senate Bill 927 has been voted due pass. I now move that we bring forth Senate Bill 928 before the committee. Do I have a second? Second. Having a second, or all those in favor signify by saying aye. Aye. All those opposed say no, and the ayes have it. The bill is now before the committee. This is the bill that Senator Lewis presented several weeks ago on criminal offenses. I do have a substitute ending in .04C. Is there any discussion on the substitute that's been distributed? Seeing none, I now move that we adopt the Senate committee substitute for Senate Bill 928. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those opposed say no. The ayes have it. Senate committee substitute for Senate Bill 928 has been adopted. I now move that we do pass Senate committee substitute for Senate Bill 928. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting, 5-0.
By a vote of 5-0, the motion passes. I now move that we bring up the substitute that we just heard on Senate Bill 1015. Do I have a second? Having a second, the bill is now before the committee. I have a substitute. You all have the substitute, ending in .02C for Senate Bill 1015. Is there any discussion? Hearing none, I now move that we adopt the Senate Committee substitute for Senate Bill 1015 that was just presented to us. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those opposed say no, and the ayes have it. Senate Committee substitute is adopted for Senate Bill 1015. I now move that we do pass Senate Committee substitute for Senate Bill 1015. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting, 5-0.
By your vote of 5-0, motion passes. I now move that we bring up Senate Bill 949 by Senator Brattin that was heard many weeks ago on judicial issues and punishing judges that allow reoffenders to go out who have committed further crimes. Again, this is Senate Bill 949. Do I have a second to bring forward Senate Bill 949? All those in favor signify by saying aye. All those opposed say no, and the ayes have it. Senate Bill 949 is before the committee. There's no Senate Committee substitute. Is there any discussion on the underlying bill? Hearing none, I now renew my motion that we move do pass Senate Bill 949. Do I have a second? Second. Having a second, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting, 5-0.
By a vote of 5-0, motion passes. I now move that we bring up the last bill, Senate Bill 1421, that I brought before this committee last week on drones and aircraft, allowing for law enforcement to restrict them in certain areas and bring them down in certain areas. Do I have a second? Having a second, the motion, or the bill is now before the committee. Is there any discussion on Senate Bill 1421? Hearing none, I now renew my motion that we vote do pass Senate Bill 1421. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer, Gregory 15, Brown 26, Berger, May, Roberts, Schnelting, 5-0.
By a vote of 5-0, motion passes on Senate Bill 1421. I now move that we go out of executive session and go back to public hearings. Do I have a second? Having a second, we're now back on public hearings, and we're going to bring forward Senate Bill 1587 from Senator Ben Brown, the 26th.
Thank you, Mr. Chairman, members of the committee, for the opportunity to present Senate Bill 1587. Currently, Franklin County, located in the 20th Judicial District, has 3 associate judges. This bill provides for an additional associate circuit judge. Franklin County is a circuit with only 2 circuit judges. An additional associate circuit judge would allow the circuit judges to take on fewer domestic cases and would allow us to spread out jury trials. Between May 2025 and December 2026, the Division I Circuit Judge had 157 total jury trials set. Of that number, 36 were high-priority child sexual abuse cases. In the same time, in Division II, there were 118 jury trials set. Of that number, 23 were child sexual abuse cases. If you take out Cole and St. Louis counties, Franklin County has been in the top 4 or 5 in the state in terms of needing a new judge based on judicial weighted workload. I spoke with the presiding circuit judge who grew up in Franklin County, practiced law there, and now serves as a circuit judge. And here were his observations. The county is growing rapidly. With growth comes crime and more families who need access to courts. Our county has recently built a new jail. Prop P was recently passed to fund additional law enforcement, to hire more police, and to provide them with all they need. Our prosecutor's office has grown, I believe, now to a staff of 12, 13 attorneys. While all that has happened, we have remained with 5 judges, 3 associate circuit, and 2 circuit. On a daily basis, I'm trying to find time to set trials, to give victims of crime their day in court in a reasonable amount of time. In fact, just today I had to continue a child sex jury trial that is set to begin in a couple of weeks and last 5 days. That particular case was filed in 2021. I did not have a free week to move this trial to the rest of the calendar year, but I will move things around to accommodate this case. But this means other cases will get bumped. Bottom line is that people deserve access to justice. Franklin County is in great need of an additional associate circuit judge, and would appreciate the committee's support on Senate Bill 1587. Thank you, and be happy to answer any questions.
Thank you, Senator. Are there any questions? Seeing none. First witness in support of Senate Bill 1587, please come forward. You'll have 5 minutes. Arnie, is that a new shirt? I haven't seen that one yet.
Probably in the last couple. Yeah, probably the last month. Yeah.
I like
Wore
it.
it twice. Yeah.
Begin when ready.
Getting more leads.
What's that?
Having more leads.
I can send you some more.
Okay, cool. Thank you very much, members of the committee. My name is Arnie A.C. Dienoff, State Public Advocate. Sorry I was late. There was a backup on the bridge. Mr. Chairman, if you just indulge me, I'd like to go back and say that I'm in support of Senate Bill 1587, if that's okay, and here's my form. And then I'm also in support of SB 1015. We have a number of circuits throughout the state. I would like to see a reevaluation of our circuits and maybe redeployment of judges. There are some counties that have lost population, some counties that have gained, especially on the eastern part of the state. St. Charles, Franklin, Jefferson counties have gained tremendous gains in population growth. It seems like the population trend is going northwest, in a northwest direction. Lincoln County, Warren County, even Montgomery County is seeing a great number of growth in population. Sprawling subdivisions are increasing every year. As we all know, Washington is the main city in Franklin County. It's growing by leaps and bounds. I believe that Union and St. Clair are also growing at moderate rates. It's a growing Franklin County. By adding an additional associate judge, this will lower the caseload for the judges currently in the circuit. It will provide faster court trials for defendants, and victims would know where they stand. I think it's important that we get to some type of normacy in terms of a speedy trial rather than putting things off for years to get a trial. So therefore, I highly support SB 1587 along with the one granting additional 2 judges to the St. Charles County Circuit Court, which we heard about a month ago. Thank you, Mr. Chairman.
Any questions? Seeing none. Next witness in support of Senate Bill 1587. Seeing none. Any in opposition? Seeing none. Any informational purposes? Seeing none. Senator, any closing remarks?
Thank you to the committee.
You're welcome from the committee. That will conclude the public hearing on Senate Bill 1587. For everyone who is here on Senate Bill 1189, it is going to be moved to next week as the senator is ill and will be unable to attend today. We're now going to move to the last bill, which should be a very uncomplicated one whatsoever, possibly a consent bill. House Committee Substitute for House Bill 2641, Representative Hinman, please come forward. And just to remind everybody, the first witnesses for and against, you will each have 5 minutes. We will alternate, and then we'll move to 3 minutes. Any redundant testimony, we will kind of shut down as we have to be out of here a very certain time. With that, Representative, please proceed.
Good morning, Mr. Chair, members of the committee. My name is Representative Dave Hinman. I represent the great city of O'Fallon in District 103. I'm here today to present House Bill 2641 for you. I've been working for the past 18 months to come up with a compromise bill for the sale of intoxicating hemp products for the state of Missouri. The biggest goals have been keeping the products out of the hands of children and testing them to make sure that the businesses are selling safe products. That all changed on November 12th of last year when Congress passed and the President signed H.R. 5371. Within that continuing resolution in Section 781, all intoxicating hemp products are no longer legal under federal law beginning November 12, 2026. The bill before you will mirror the federal regulations stated in that bill and end the sale of intoxicating hemp products November 12, 2026. The exact language is spelled out in paragraph 11 on the last page. This bill will create the Intoxicating Cannabinoid Control Act. In addition to a couple of items that were requested to adjust in this bill, first, House Bill 2641 states that no state agency or employee shall disclose to the federal government any information on persons that have applied for or obtained any type of card relating to cannabis. And second, House Bill 2641 states that upon written request of a consumer, a facility shall not create or retain any records on that consumer. This bill specifically gives primary responsibility to the state attorney general and asks that the office use multi-jurisdictional enforcement to direct coordination with the Department of Public Safety, the Missouri Highway Patrol, prosecuting and circuit attorneys, while collaborating with local, county, municipalities, and governments. I'm also aware over the past 3 years we've heard many approaches to solve this issue. The federal government has stepped up and set the standards at this time. And again, House Bill 2641 will codify that for the citizens of the state of Missouri. And with that, I appreciate your time. I'd be happy to answer any questions you may have.
Representative, thank you for bringing this, and thank you for working diligently over the past couple of years. I know this is one of the most complicated bills, especially now that the federal government has acted. And maybe this isn't a good question from me to you because I think we're probably talking the same law enforcement personalities, but it's my understanding that this bill is necessary because if we don't pass something which places in our state statutes some form of a mirror or some sort of a prohibition, this is interesting. You don't need to duck down, that's fine. I'm sorry, that was distracting. I hope that's a good drink, Senator Berger. So it's my understanding that the state law enforcement needs something in our books if they're going to do this and enforce this, because just relying upon the federal statutes and the federal prohibition, you would have to rely upon federal enforcement as well. And our law enforcement is saying that's probably not going to happen. Is that your understanding of this?
That's exactly correct. And in order to put this in the hands of our local law enforcement, local prosecutors, we have to have something in state statute in order for them to proceed with that.
Now, this has got a lot of language in here that if you're new to this bill, you're probably thinking this is Latin. A lot of different verbiage describing the certain types of these hemp-derived THC products. But I want to direct your attention to page 15, because this is something new to me, and I just kind of want to get your take on it. Lines 135 through 157, I think you stated it was the last section. Can you describe what is this doing, section 11?
Sure. In section 11, we worked to try to get something put in for a compromise. We felt as though on November 12th, on that date, no matter what, if the federal government doesn't act on this, all hemp-derived products are banned throughout the country. It doesn't matter what it is. The number one issue that we've had, not only with local governments, local prosecutors, our attorney general, and our governor, is mainly items that come out of hemp stores or convenience stores that are high-dose products, and those are edibles, gummies, smokable products. Those are the issues that are the biggest problems in the state of Missouri. So those specifically are excluded out of there. If by any chance the federal government says we're going to give an extension on this to try to figure this out, those products are still gone as of November 12th, 2026.
Now, this section 11 would still allow drinks, correct?
It would if the government put an extension on. If the government does nothing and remains with the bill that's currently intact, then drinks would be allowed on that extension.
Now, my only, I guess to play devil's advocate and be an attorney and dig into this stuff, this would allow for a 50 milligram, 100 milligram drink to be sold, correct?
In this bill, it would.
Okay.
There are two other bills, one in the Senate, one in the House, that is actually working to put rules and regulations in place on hemp-derived drinks, THC-infused drinks.
And the last comment I'll make before opening this up, I think last night, and correct me if I'm wrong, I think that there was in Congress, there was some action on this issue. An attempt was made to extend this, and I believe that failed. Is that your understanding as well?
It is my understanding also that it failed in committee yesterday.
Okay. Any questions for Representative Hinman? Seeing none, your first witness in support, please come forward. Make sure you have a witness form filled out, and you will have 5 minutes.
Good morning, Mr. Chair, members of the committee. Tom Robbins from Occan, in strong support of House Bill 2641, aka ICCA. I want to first thank Representative Hinman for nonstop work for the last 18 months, which I know feels a lot more like 18 years. So hopefully this is the last time I have to come in front of you and talk about cannabinoids. Thanks to Representative Hinman's leadership, the Missouri House passed House Bill 2641 with bipartisan supermajority support, and we urge the Senate to do the same. The ICCA is straightforward. It aligns Missouri law with Congress's newly enacted federal definition of hemp by making it clear that if a cannabis product is intoxicating, it's marijuana and should be regulated as such. The most urgent reason to act is simple. It's about enforcement. As Representative Hinman stated, as 11-12-26, these products become banned, and we want to be ready to enforce it here in Missouri. As mentioned, our state and local law enforcement enforce and prosecutors enforce state, not federal law. And the consequence of not acting is that if we don't align Missouri's definition with the federal definition of hemp, then we invite gangsters, including Chinese nationals, to descend upon Missouri as they have in Oklahoma, Michigan, and Maine, to infiltrate our systems and our way of life. So it's kind of an open door to gangsterism. Passing the ICCA solves a real and immediate problem. It gives Missouri law enforcement, including the Attorney General, clear authority to act. It provides clear lines for law enforcement and relevant government agencies to enforce. Bottom line is any THC product in Missouri exceeding 0.4 milligrams total THC per container is marijuana and therefore not permitted outside highly regulated dispensaries. And then conclusion, it's important to note what the ICCA does not do, and it does not regulate legitimate hemp and industrial hemp. It thereby protects legitimate hemp farmers and CBD businesses. It protects your constituents, including minors, from accessing or purchasing intoxicating THC products that are perhaps untested and unsafe. And it also ensures Missouri is positioned to enforce the law come November 12th. Thank you very much for your time. Happy to answer any questions.
Any questions? Seeing none.
Thank you.
We're going to move to the first witness in opposition. Make sure you state your name for the record, and you'll have 5 minutes.
My name is John Grady. I'm a combat veteran, hemp farmer, hemp manufacturer, and retailer. I will tell you that this legislation regarding hemp and the regulation thereof is filled with dishonesty and dishonest individuals. Individuals beholden to an illegal, federally illegal, illicit industry, which is the marijuana industry. They do so, they say things in subterfuge and say that they are doing it to protect the public. We found out that every time all the news articles that they have shared are not in protection of the public because the products that have been used in those instances where the children have been poisoned have been marijuana, not hemp. We have seen this time and time again. We have come up here. We have seen what the federal law is and what the statutes are. We have seen that there was originally going to be provisions, and Mr. Hinman told me and my wife to our face that he was working to protect our industry for our beverages and the gummies we make. That was not the case. We're here before you today because I'm telling you veterans and many others utilize these products. Now, there is the consternation of what's going on federally, and yes, we already knew yesterday that committee was not going to pass that legislation. That's coming here in a CR that's coming up. Those are the deals that are working in the background, because I just spoke with Representative Bob Onder and Representative Ann Wagner the other night, who told me that yes, they know what's going on with hemp, and they are looking to protect legitimate hemp businesses that do things the right way. For Missouri to do this is really crazy. And to talk about the dishonesty in this, most of my products are 10 milligrams and below. Those are what are called low dose. However, Mr. Hinman's bill goes up to 50 and more milligrams. Says it's for beverages, but not gummies. They affect you the same way, just different time frames. So honesty in politics talks about doing what's right, doing what the Constitution says, and not using subterfuge of lobbyists to go forward and using it, basically use lawfare, the same horrible stuff they're using against President Trump, against the legitimate farmers and veterans that are doing this. And that's what we've seen for the past years, because bills to regulate and actually regulate this product have been pushed by the wayside. And it is abhorrent, especially when you look at the veterans who benefit. We have senior citizens that come into our shop that are 85, 86 that come in for their nighttime sleep gummies. Guys that come in for pain doses to sit there and be able to make it through the day. And to find this legislation going through and the dishonesty involved in the process from the lobbyists, from the legislators involved, I find reprehensible. That's all I'll say.
Senator Gregory, please proceed.
Thank you for being here. A couple questions. I don't know, maybe you and I are on a different page as to what hemp is versus marijuana. So can you explain to me the difference?
The definition by hemp in the 2018 Farm Bill talks about all parts and pieces of the hemp plant, all isomers, everything that can be made from that, to 0.3% delta-9 THC. That is the law currently. That is changed to what we have that we're seeing here, but what we're seeing here is not opening where if the federal law changes. In fact, Mr. Hinman even said if the federal law changes, he doesn't care. And I find that reprehensible.
So,
because we're saying one moment we want to follow the federal law, but we're supporting an illegal industry and by doing that. You say you're going to follow the federal law, but you're doing so at the behest of a federally illicit industry. Remember that, sir.
So, of course, the current definition that hasn't been enacted or won't go into effect until November 12th of this year, it has a certain amount of THC by dry weight, right?
The current one that is in place is by dry weight. The new legislation is as a
what is the
0.4,
purpose,
which would make my chicken feed illegal.
What is the purpose of having that definition, the difference between hemp and marijuana? What's the purpose of having that definition?
Taxation purposes. And honestly, talking to the architects, because I was in D.C. this year talking to the architects that helped write that language. And
that is not the purpose. The purpose is the intoxicating effect.
No, you're wrong. See, sir, intoxication has no play, because intoxication is a fallacy, because hemp cannot be intoxicating, because it is not toxic to the system.
I want you to say that again. Hemp cannot what?
It is not toxic to the system.
Very
Cannabinoids are not
Very
toxic.
Good.
Sir, do you realize, you understand you have no concept
I
what
agree
you're
with
talking?
That. I do.
Do you understand you have no concept what you're talking? By having no concept, then you should not legislate what you have no concept on.
Hemp?
Because what I just told you is hemp is not intoxicating. Cannabinoids are not intoxicating. Marijuana is not intoxicating. They are inebriating, yes, but they are not intoxicating. So if we are going to talk law, we must talk law and talk language and definitions correctly, sir.
Okay. Maybe you and I have a different definition of intoxicating, but let me tell you this. The purpose, my belief, the purpose of the law is to distinguish the difference between what is and what is not intoxicating. It has an intoxicating effect. That is the purpose of the current law, and that is the purpose of the new law coming into effect.
And it fails in its
Let me
regard.
finish. Let me finish. I let you finish. Now let me finish. The purpose is the intoxicating effect. That's it. That's the purpose. And what we have found is that folks have scientifically used a workaround to get around the current definition to give an intoxicating effect. So the feds came in and said, hey, that wasn't the point. The point was if it's having an intoxicating effect, it's marijuana, not hemp.
And you
That
were wrong
is what
again,
we're
sir, and
doing.
I'll tell you why.
Okay.
Because our Delore full-spectrum tincture, which is non-intoxicating, uses 150 milligrams of CBD and 2.8 milligrams of THC. It uses the THC because you need THC to activate the CB1 receptors, which are responsible for the central nervous system. That's how we deal with neuropathic pain. We deal with other nerve pain issues. What you do, sir, is you are not operating in the interest of the people. In fact, you are violating Article 1, Section 2 of the Constitution by placing winners and losers out there.
Okay, well, we're going to have to disagree because here's the deal. Hemp that is not intoxicating is still legal. It's legal today.
No, it's not,
It'll
sir.
be legal
My chicken
tomorrow.
feed
It
becomes
will.
illegal by this bill.
It will. It just
My
cannot
chicken
be
feed becomes
intoxicating.
illegal by this bill.
Okay, no, that is incorrect.
No, that
That's
is
all the questions
perfectly
I have.
correct because the flour residue within my chicken feed from harvesting
any
leads me
further
to have
questions?
more than 0.4 milligrams in my 25-pound sack.
Having no further questions, we're going to now move back to those in favor. Next witness in favor, please come forward. Begin when ready.
Good morning, Mr. Chairman, members of the committee. My name is Ron Leone. I'm the Executive Director for the Missouri Petroleum and Convenience Association, and that means I represent many of your constituents who own, operate, or supply gas stations, convenience stores, and truck stops. Mr. Chairman, this is a complicated issue with lots of moving parts, so most of my testimony will try to define all the different players so that you as policymakers can make an informed decision going forward. As the sponsor said quite correctly, Congress, effective this year, November 12th of this year, effectively bans all intoxicating hemp-derived products. Now, we are hearing, many insiders in Washington, D.C. are hearing that Congress may extend that deadline or that President Trump may get involved as well, and therefore they will not have a ban effective that day. Senator Gregory has a bill, 904, which bans all intoxicating hemp-derived products unless they're sold in a dispensary. Senator Henderson has 993, which only allows the sale of intoxicating hemp-derived beverages, but puts into place a three-tier system with taxation and regulation. And of course, Representative Hinman, the bill before you today, which we support, carves out an intoxicating hemp-derived beverage only carve-out, but he doesn't put in a lot of taxation and regulation. We support Representative Hinman's bill, Mr. Chairman, members of the committee, but we would like to see it expanded so it automatically incorporates whatever the feds do. So if the feds ban all the products effective November 12th of this year, done deal. If they kick the can down the road and still allow the sale of intoxicating products, we want to be able to sell those as well here in Missouri. If they only allow beverages, that's what we want to be able to do. So the bottom line for us, again, Mr. Chairman, MPCA, we support a fair and level competitive playing field so that your constituents, my members, can sell all the federally lawful and authorized products that all the other states may or may not be able to sell, depending on what Congress does. Banning them outright or beverage-only carve-outs are not really appropriate, and certainly we would ask that you expand this bill to allow whatever is authorized and lawful under federal law. I'm happy to answer any questions, Mr. Chairman. Thank you for the opportunity this morning, and that's all I have.
Thank you, Ron. The one question that I asked Representative Hinman on that last page, that one section that's a little confusing and, in my opinion, would allow for 100 milligram, 200 milligram beverages. I see the intent behind it, but do you think that needs to be modified, or is that something that you're fine with?
If it's the public policy of this committee and the legislature to carve out beverages, you're going to have to define it better than it is in paragraph 11, and maybe incorporate something like Senator Henderson's bill, which has a 3-tier system, has limits, regulations, taxes, things of that nature. This is just a general carve-out, leaves a lot of unanswered questions. So yeah, if that's the direction you're going in, you're going to have to put some meat on those bones.
And what are your, I know we've gone back and forth on different iterations of this bill. What are your clients more interested in? Would it be a wider range of products that they could sell, or sending them to dispensaries? Or what if you could wave a magic wand for your clients, what would that look like?
If I could wave a magic wand, again, it's whatever ultimately ends up being lawful under federal law for all 50 states would apply here in Missouri as well. So if the feds say nothing, then of course that's the answer. If the feds say beverages only, that's what we sell. If the feds say a plethora of products, we want to be able to sell those products as well. And the problem has been we haven't been able to pass. We've had to self-regulate. Some do better jobs than others. We haven't been able to pass a bill which provides some reasonable guidelines and guardrails, 21 and over, behind the counter, things of that nature. And I think that's been purposeful, because I think the marijuana folks don't want to legitimize the hemp industry so that there's more of a push to put it in dispensaries. But we've been advocating for a regulated and tax system for years. We have not been successful. And again, we don't want to hamstring your constituents here in Missouri if the guys in Arkansas and Illinois and Kansas could sell products that are ultimately lawful under federal law.
So if this federal prohibition sticks, and that's going to be the law of the land, your clients would rather have no state, confusing statutes that allow certain products while the feds say nothing's allowed?
Well, if the feds say none, we're toast. You can't sell anything here. If the feds say everything, we want to be able to do that, but we ask for guidelines as well, because we think, of course, children need to be protected, and self-regulation doesn't always work. If the feds limit it and just say beverages only, we want to be able to do that as well. We want to be able to compete like all the other retailers in all the other 49 states, and not just do some or none of what the feds may allow.
Senator Gregory.
Mr. Leone, thank you. Just one quick question. Your involvement in negotiations on this House bill, were you involved?
Say that again.
Were you involved in the negotiations on this House bill?
The House bill came out of committee. I testified in support, and it came out of committee, and it allowed all the products that would be allowed under federal law. There was an amendment on the floor which just limited that to beverage carve-outs. Now, we'll take beverages as that's all we can get. We think it's appropriate to go back to the committee substitute, which again allowed all the lawful beverage, all the products that may or may not be lawful under federal law, so that again, your constituents are allowed to sell or not whatever is lawful under federal law.
Yeah, but Representative Hinman included you in discussions and things like that in his bill.
Yeah.
Great. Thank you.
Thank you.
Any further questions? Seeing none.
Thank you.
Going back to those in opposition of House Committee Sub for House Bill 2641. You will have 5 minutes. Proceed when ready.
Thank you, Mr. Chair. Members of the committee, Jake Silverman, registered lobbyist for Missouri Hemp Trade Association. We just want to go on record in opposition to this bill. Mr. Chair, as you stated about page 15, that is one of our biggest concerns. We don't think that a beverage carve-out is fair. We don't think it's reasonable. And there was, mention of other bills that do regulate these beverages. If it's okay to regulate beverages in the future, why is it not okay to regulate the gummies and the vapes and the flour as well? I see as cutting out 90% of the market with regards to these products other than beverages is just a simple way to make essentially a monopoly. And so we would like an opportunity in the future to be able to regulate these products properly, make sure that they're not in the hands of children, making sure that they're properly packaged, not enticing to children, tested properly, but we are not able to do that based on page 15 of this bill. And so that is our biggest concern, and I'd be happy to answer any questions.
Any questions? Senator Gregory, please proceed.
Just very briefly, thank you, Mr. Silverman, and obviously you and I don't see eye to eye on this, but it has not stopped you from being the consummate professional and very respectful, so I thank you for that.
I appreciate that.
Your involvement as Representative Hinman kept you involved. How has your involvement been in the negotiations?
So we were not at the negotiations whatsoever. I will say that while the process was going on and negotiations were being made between the Hemp Beverage Association and MOCAN, we were privy to some of the potential amendments, but not the one that you see here today. I did not find out about this amendment until about 20 minutes before it was perfected, and it did. Obviously, it was perfected, I think, on a Tuesday. Third read on a Thursday or something like that. Did not give us a lot of opportunity to discuss the amendment with legislators in the House, and so that was a very big concern for us. And so, that's where we stood.
When you say the one today, you talk about the drink exception.
Oh, sorry.
What are you talking about when you say the not involved in the amendment? Are you talking about the drink exception?
The drink, the drink part. Yep,
gotcha.
Correct.
Okay, thanks.
Further questions? Seeing none. Now moving back to those in favor, you will have 3 minutes on House Committee Sub for House Bill 2641.
Good morning, Mr. Chair. My name is Justin Arnold. I'm the Chief of Police in Ozark, Missouri. I'm here on behalf of the Police Chiefs Legislative Coalition, which represents police chiefs from across the state of Missouri. We are in favor of this House bill. Ultimately, the products that are being discussed are intoxicating, they're unregulated, and they are on store shelves where children can go in and buy them. We all know that on November 12th, federal law will take place. However, that's not going to solve that problem here in Missouri. We do need action to be taken so local law enforcement, all the way up to our Attorney General, can protect Missouri children and teenagers from these unregulated products on store shelves. So we would encourage you as the Police Chiefs Legislative Coalition of Missouri to take action to protect Missouri children and teenagers and allow us the ability to protect our citizens.
Thank you, Chief. Thank you for being here and the work that you do for our state.
Yes, sir.
One of the witnesses alluded to, in previous testimony, mentions of these types of products having adverse effects and requiring medical attention, overdoses, hospitalizations, being false, and all of those being attributed to marijuana and not these types of products. Is that your experience, or do you have experience with any people in your community having adverse effects that require hospitalizations or medical treatment after using these products that are the topic of this bill?
Right. So I don't have any specific examples of that, more than parents who have come forward and may have sought medical attention due to the concern of their child ingesting an unregulated product that they really have no idea what may be involved there. So to answer your question, anything that I'm aware of in my jurisdiction has been more of a concern of the parent due to the unknowns with a product that may have been ingested by a teenager. That's typically the age we see being affected by this.
Any questions?
Yes.
Senator May, please proceed.
Good morning. How are you?
I'm well, ma'am. Thank you.
Good. My question is this. So when you have those situations that you encounter with those parents and a teenager who ingested the product, are you able to trace the product back to where the teenager got it from? Or has the product been analyzed to see what the product actually is?
So in a lot of those instances, we're getting third-hand information on where they may or may not have got it from. And it's very difficult to direct resources, especially if maybe they're not in my jurisdiction where those products came from. And without the clear legal authority to do things, we don't know that what product we're dealing with necessarily. And so that causes difficulties in fully investigating whether or not we have clear law violations and being able to move cases forward that way. Does that
Yeah, that
answer your
answers
question,
the
ma'am?
question. So basically, you can't tie it to any specific hemp product, basically.
That would be the crime lab that would do that, you know, through their
Yeah.
testing. And again, without that clear direction, it's very difficult to do that.
So what basically the Constitution already says that no cannabis can be sold in unlicensed places. So basically, we do have the authority to do it, but I guess if we move that language to the statute, that will give you statutory authority to go after products that, you know, or cannabis that are being sold in places that are unlicensed, because that's what we're talking about.
It makes it much more clear for us to know where to focus our resources on things that could be dangerous to our children.
Thank you.
Yes, ma'am.
Any further questions? Seeing none. Thank you for your testimony today. Next, in opposition of House Committee Sub House Bill 2641. Jorgens, you change your mind? I saw you go up and down quick. And just a reminder, make sure you have your witness form. Looks like you have it. You'll have 3 minutes.
Good morning. My name is Tara Latil, and I'm speaking on behalf of CBD American Shaman, a Missouri-based company that's been part of the state's hemp industry since long before it became news. Our company works with hundreds of small retailers, employs Missourians across the state, and serves thousands of adult consumers who choose federally legal hemp products as part of their wellness routine. Many of these consumers, like was mentioned before, are veterans, seniors, working parents, and everyday Missourians looking for alternatives that can help them manage stress, sleep issues, discomfort, and other wellness concerns. We do support reasonable regulation. We support age restrictions, product testing, labeling, and consumer safety standards. Responsible businesses like ours have advocated for these safeguards for years because consumer safety and transparency are essential to maintaining public trust. However, what we cannot support is HB 2641 as written because it doesn't simply regulate hemp, it effectively removes the existing hemp marketplace. The bill regulates hemp products using total tetrahydrocannabinol, setting limits of 0.3% total THC by dry weight and 0.4 milligrams of combined tetrahydrocannabinols per package. Using a total THC calculation means the bill doesn't just address delta-9 THC, it captures multiple cannabinoids, such as delta-8, delta-10 THCA, and other THC compounds. Many of these compounds, though, are not intoxicating in their natural form, yet they'd still fall under the bill's restrictions. The bill also prohibits certain synthetic cannabinoids, further expanding the scope beyond what many people think of as traditional THC products. The most significant issue is what happens when those limits are exceeded. Under HB 2641, products above those thresholds are classified as marijuana and must be regulated under Missouri's marijuana licensing system. That means cultivation, manufacturing, testing, distribution, and retail sales would have to occur through marijuana businesses operating under Article 14. As a result, the practical effect of this bill is that many hemp products currently sold across Missouri would no longer be allowed to be sold by hemp retailers. That means hundreds of small Missouri businesses, retailers, distributors, and manufacturers would be pushed out of the market overnight, and the impact will go beyond just hemp companies. Packaging suppliers, shipping companies, marketers, construction contractors, marketing firms, landlords, and many other local businesses that support this industry would also feel the economic damage. These are family businesses, farmers, veterans, and entrepreneurs who built their companies under the rules that Missouri itself established after the federal farm bill legalized hemp. These businesses have followed the law, paid their taxes, hired employees, signed leases, and invested their life savings based on the legal framework Missouri put into place. Changing the rules now and shutting them down is not regulation, it's pulling the rug out from under the very businesses that played by the rules. If HB 2641 passes, the consequences would be immediate. Small businesses would close, jobs will disappear. Consumers are not going to stop seeking those products. They'll just simply turn to online sellers or unregulated sources.
While your time has expired, I'll give you a couple seconds to wrap up.
Okay. Basically, it doesn't improve safety, it just weakens it. This is an opportunity that you have to create a balanced regulatory framework that protects consumers while allowing responsible businesses to continue operating.
Thank you for your time and testimony. Do we have any questions for the witness? Senator Gregory. please
Yes,
proceed.
just real quick. You had said that you think there are some hemp products that are not intoxicating but would be prohibited by this bill?
Because Delta 8 is found in small amounts, as well as all the other products, THCA, for instance, in its natural form is not intoxicating, but it would still be banned because it's part of the plant.
THCA with applied heat would become very intoxicating, right?
If you apply heat, yes.
Okay. So it is intoxicating. THCA...
Not in its natural form, though.
Okay, but with a simple application of heat, it is intoxicating. Yes.
Yes.
Okay, thank you.
Any further questions? Seeing none. Thank you again for your testimony today. Moving back to those in favor, Jorgen. I was waiting for you.
I always like to be invited by the chairman. Mr. Chairman, members of the committee, Jorgen Schlemer on behalf of the Hemp Beverage Alliance. We are in support of the bill. We appreciate all the time that Representative Hinman gave us to visit. I will say that we knocked on his door frequently and talked to him about this bill a lot. And what we attempted to do is, and because I represent a very narrow segment of all of the products that are out there, I think Mr. Leone and others have talked about more products than just this, is that we saw from the legislature that for some reason they identified the products that we represent a little differently and saw that our stream of commerce, that, hey, these are products that are responsibly produced. I'm not saying that others are not, but I'm saying this was the perception of many. Responsibly produced, responsibly sold, and responsibly consumed. And therefore, those products should be able to, if the federal law allows. Now, November 12th, it's the big date. If November 12th comes and the federal government does, as we keep saying, does not kick the can down the road, then really, a lot of this friction is almost for nothing. However, the rest of this trigger does say that the state then has law enforcement over all of those products, and I think that was the representative's intent. And if they do kick the can down the road, then those products, at least that we represent, could remain in the stream of commerce. Now, I will go one step further, and it's been mentioned today. Senator Henderson and Representative Justice do have a bill, and I do think that while I do believe that most retailers do require age 21 for our products, that would make it mandated 3-tier system and so on and so forth. So we do believe that these two bills could be in tandem to make even a better stream of commerce for those products. Thank you.
Any questions? Senator Gregory.
I think you made it very clear. You were involved in the negotiations in this bill as well, right?
I knocked on Representative Hinman's door probably more than he wanted.
Good for you. That's your job,
yeah.
And you're doing it well.
Yes.
I just think, I hear you that I guess you believe drinks can be produced and sold responsibly. But
just like alcohol.
Why couldn't gummies technically be produced responsibly?
Perhaps they can. I don't represent that industry, so I didn't want to speak for them. I don't know. I don't know that industry well. I took guidance from my client, obviously, on
Fair
our
enough.
products.
All right.
And
thank you.
Yeah, you bet.
Senator May, please proceed.
So basically, you have clients that have responsible hemp products that are sold and created responsibly.
Yes, Senator.
Okay, very good. That's all I wanted to reiterate.
Yes, thank you.
Any further questions? The left side of my committee today has just been very silent, very active on the right side. I expect more of you today, Senator.
We're not sure what was in his drink, so.
Yeah, you might have a hemp drink. Any further witnesses against House Committee Sub House Bill 2641? Seeing one. You have 3 minutes. Please proceed when ready.
I wouldn't get your bill in the House. Thank you, Mr. Chairman, members of the committee. My name is Arnie C. Acdinov, State Public Advocate I oppose this bill in the House, and there's a number of different issues here. What I want to start out with my statement is, who is commanding and running our state capitol? Is it citizen legislators? Carla May, or Senator May? Maybe she's running it. But is it lobbyists that are running it, that we're taking all the testimony and all the marketing and all the sales pitches? Or is it citizen legislators relying on experts, people in the field, scientists? I haven't heard this committee or the House committee hold death-finding informational public hearings to get public testimony from some experts. But what I see here is a lobbyist industry, six-figure lobbyists from the marijuana industry that are clearly out to abolish and descend the hemp industry in its totality. I understand the United States Farm Bill, but guess what? When it came to marijuana, we told the federal government to go screw themselves. We didn't listen to them and about their schedule of drugs and marijuana. We marched to our own tune here in Missouri, and we enacted marijuana, which I was in favor of. We didn't follow federal guidelines and federal enforcement regulations. No. So let's not do it for hemp either. The benefits of hemp take away options for adults. Now, as opposed to the House Committee and the Public Safety Committee of the House, and I support Senator Henderson's bill, Senate Bill 993, which covers hemp beverages. As a matter of fact, I testified for that bill. It allows for sales, a 7% tax, licensure. We can keep tabs on the industry. But this bill decimates and shuts down the hemp industry to its totality. It's being driven by the marijuana lobbyists and the marijuana industry. The federal government and federal law enforcement has bigger fish to fry. Let me tell you, they have bigger fish to fry. Fentanyl, methamphetamines, and there's 2 more drugs coming up from South America that Narcan's not going to work to bring back people. I agree with disclosure, labeling, testing, registration, inspection, enforcement. I have severe issues with marketing, shapes, enticement before children at convenience stores. We're all on board with getting that under control and enforcing that mechanism. But this bill doesn't really talk about it. It's mirrored with a lot of eye candy at the beginning, and then screw the hemp industry. We want the marijuana industry to be the dictator.
Arnie, while your time has expired, I'll give you a couple more seconds.
Thank you so much. It's squeezing the hemp farmer. This is a mere scheme of the bill, legislation. At the beginning of the bill, read between the lines, committee members. This bill is clearly squeezing and abolishing hemp growers, hemp farmers, hemp businesses, trying to help Missourians for profits by the whole marijuana industry. And I want to finish with this, Mr. Chairman. Why does everything in this building come down to the almighty dollar? Why? Why don't we put people first over money, over profits, over greed, control, power, and access? Thank you very much, Mr. Chairman. I'm highly opposed to this HCS HB2641.
Any questions for Mr. Dienoff? Seeing none. Thank you for your testimony. We're going to go back to those in favor of House Committee Sub House Bill 2641.
Good morning.
And ma'am, make sure you have your witness form.
I don't, but I will.
I knew you didn't.
Before I live.
Proceed and ready.
Good morning, Mr. Chairman, members of the committee. I'm Kathy Harness, and I'm here today on behalf of the Missouri Beer Wholesalers Association, and we are in support of this legislation. Currently, Missouri beer wholesalers, not all, but some of them, are distributing THC beverages, but nothing over 10 milligrams. That is our limit that we do. And Senator May, to your question, if a beer wholesaler delivers product to a retailer and something happens or goes wrong, that beer wholesaler can go back in there, they'll know the day they took it, where they took it. So it is traceable. It's the very same that they can do with alcohol, because there have been a few recalls on certain alcohol, and they're able to go back in and find the product, get it off the shelves and out of the market. We are not opposed to other products, other hemp, low-dose hemp products. It's just not in our wheelhouse that we deliver beverages, or we work with beverages.
Thank you for your testimony. Any questions? Seeing none.
Thank you.
Thank you for your time today. Going back to those in opposition of 2641. Seeing none. Going back to those in favor of House Committee Sub House Bill 2641.
Good morning, Mr. Chairman, members of the committee. Michael Gibbons representing Total Wine & More. Total Wine & More is a national alcohol retailer. They have 9 stores in Missouri, St. Louis, St. Charles, Springfield, Kansas City, across the state. Very much in support of the bill. We also are in support of the other bills mentioned, the Henderson and Justice bills, to create a regulatory framework. That framework we think makes sense, and quite frankly, it's been our corporate policy since Total Wine started selling the hemp-infused beverages. We think 10 milligrams or below is the proper limit. As a company, we're very aggressive about preventing sales, doing everything we can to prevent sales to minors. We certainly apply that to this product as well. We just aren't involved in the other spaces, the edibles and other things that are out there. That's just not our business. But we think that this is a good step in the right direction. We're very comfortable with the understanding that if the federal government bans it, it's banned. If it allows it, then we'd like to be able to proceed. And we do think a regulatory structure similar to the 3-tier system as it applies to alcohol is what makes sense in the beverage space.
Any questions? Seeing none. Going back to those in favor of House Bill 2641.
Good morning, Mr. Chairman, members of the committee. Jack Carday with MoCan Trade. Don't want to belabor any of the points that have been made today, but I did want to introduce one new piece of information. Last fall, we went all throughout the state, and we purchased 55 of these products from across the state, and we sent them to state licensed testing lab, because a lot of this conversation is what are actually in these products, right? And so when that analysis came back, and you can go to MissouriHempHoax.com, get all the certificate analysis that are out there, what we found was that 96% of these were either cannabis or synthetic cannabis. 96% of these
Can you
were
repeat
not
that website? One of the senators, did you say Missouri Hemp Hoax?
Yeah, MissouriHempHoax.com. And has all the COAs that are actually out there. So 96% of these products that were labeled as hemp are actually cannabis or synthetic cannabis. And also, one of those, and they're not just a little above that 0.3% limit, one of those was 289 times the legal limit. It was being sold at a convenience store here. The other problems with those is that 29% of the products that we tested positive for dangerous contaminants, including pesticides or heavy metals. This is a straight byproduct of the fact that we don't know what's in these products. They're not tested, they're not taxed, they're not regulated. As you can imagine, this makes the job of law enforcement here in Missouri nearly impossible. When Representative Hinman introduced this bill and it was heard in the House committee, we had a really fascinating piece of testimony where a law enforcement from the community of Eureka came in and talked about something that happens every year there. They have a huge kind of flea market in the Six Flags parking lot there, and it's something that the community kind of rallies behind. It's a neat thing that they have. Unfortunately, either a year or two ago, someone was selling marijuana flower, pre-rolls, and joints at that flea market. Obviously, that was very concerning to people in the community. They called law enforcement. Law enforcement showed up there, and when they started asking about this, all the person had to say was, well, it's not marijuana, it's hemp. It's THCA, it's not marijuana. Therefore, it's federally illegal. You can't do anything. I can sit here and sell this all day long to anybody I want to. Of course, when they were asked, a lot of times, just like I think Senator Gregory asked, well, THCA is intoxicating, right? And they said, well, no, absolutely not. THCA is not intoxicating. I mean, unless you smoke that joint, unless you produce fire or it's heated, then it's absolutely intoxicating. So that's the situation right now that we've put Missouri law enforcement in. That's not fair. We've got to actually have some rules and regulations around this. I mean, hemp has almost become a marketing term here in the state of Missouri. And it's done so because if you call it hemp, it doesn't have to be lab tested. If you call it hemp, it doesn't have to pay marijuana taxes. If you call it hemp, it doesn't have to be grown in the state of Missouri. If you call it hemp, you can market it directly to kids and you can sell it to kids. And so we really wanted to get down and figure out what actually are in these products. And what we know is these products aren't hemp at all.
While your time
They're
is
just
expired, I'll
marijuana.
give you a couple more seconds.
Yeah, and so appreciate all of the everything here today. Want to just bring some of that new information to the committee.
Thank you for your testimony. Senator May.
Good morning.
Good morning.
Did you test any marijuana products at marijuana dispensaries?
Those are tested. Those are required by law to be tested.
I mean, did you buy any and test them?
No, we those are tested every day. So we purchase 55 products from across the state that are not regulated.
But when you go in marijuana dispensaries, they don't offer you a certificate of analysis for the products.
Those are every product that's in a Missouri dispensary has to be grown in the state of Missouri, has to be manufactured in the
that
state of
don't mean
Missouri,
nothing, though.
and has to be lab tested in the
What
state
does
of
that
Missouri.
mean?
What's
Just
that?
because it has to be doesn't mean that.
Yeah, the marijuana industry is the most heavily regulated industry in the state of Missouri.
I concur. I believe you. I got you. But also, if they showed up and somebody said that they were selling hemp, you still had to prove that it was hemp.
Sorry, I didn't
according
follow.
according to the Constitution.
Yeah,
You
and
still, I mean, you know,
every
if-
product that's sold in a Missouri dispensary absolutely does have to be lab tested. You're right on that.
And most hemp products offer a certificate of analysis of their products. Most of them have QR codes on them where you can scan it and get the certificate of analysis.
That is actually something that we tested. Some of them do, some of them don't. Some of them are very outdated. When you go to the QR code there, it's from batches that are months and months, if not years old. So it really, some of them are, some of them aren't. But what we've
And so
clearly
you're
found
saying
then is that a lot of this stuff isn't actually hemp. It's just marijuana that's being marketed as hemp.
So you're saying that we need to put some hemp regulations in place.
I mean, look, this is obviously the public policy here in the state of Missouri. What I'm saying is when someone comes up here and testifies today that they're following all the federal laws, that's not actually true because they're just selling marijuana. They're not selling hemp.
In the cases that you studied, not all cases.
Sure.
Absolutely. Thank you.
Any further questions? Seeing none. Going back to those in favor of House Bill 2641. Any more in favor of House Bill 2641? Seeing none. Any in opposition? Seeing none. Any for informational purposes? Make sure you have your witness form and proceed when ready.
Mr. Chairman, members of the committee, Ethan Thampy with Great State Strategies. I think we have a problem here, which is that we agree with a lot of what the proponents and opponents of this legislation have said. So I thought I would speak to specifically what the federal government is doing. So as Representative Hinman said in his presentation, in Section 781 of the continuing resolution from last November, what the federal government actually did, whether we like it or not, but this is what happened, right? The federal government has changed the definition of hemp and marijuana from the previous definition of 0.3% delta-9 THC to, I think, 4 milligrams per container of THC. So one of the things I think that has been a misconception through this entire discourse is that when this federal law becomes implemented this coming November, all the hemp products that have THC in them will be, by definition, under federal law, marijuana, right? So I think there's a question about the necessity of this bill in terms of enforcement authority. I think that enforcement authority already exists because the state of Missouri, modeling federal law, we have a trigger provision actually in our statutes to model federal law with scheduling designations of the Federal Controlled Substances Act. And the second thing I wanted to speak to was the executive order that President Trump signed on December 18th of last year. And I'm going to quote from it. Section 2B of this executive order says this will include consultation with appropriate executive departments and agencies and authorities to develop a regulatory framework for hemp-derived cannabinoid products, including development and a guidance of an upper limit on milligrams of THC per servings and CBD to THC ratio requirements. The Secretary of Health and Human Services, the Commissioner of Food and Drugs, Administrator of the Centers for Medicare and Medicaid Services, and the Director of the National Institutes of Health shall develop research methods and models using real-world evidence to improve access to hemp-derived cannabinoid products in accordance with federal law and to inform standards of care. During this meeting, Dr. Oz, the administrator of the Center for Medicare and Medicaid Services, said that they are planning to create a federal reimbursement up to $500 a year for individuals using these products through Medicare and Medicaid. So I think that, I mean, we could agree with Mr. Leone and Mr. Schleier's position, or at least Mr. Leone's position is this bill is, we support this bill, but it needs to be expanded. You know, Mr. Sullivan and some of the other witnesses have said we're in opposition to this bill because it's a ban. And we kind of agree with all of these, but let me point out here is that when the federal government completes its work to create a regulatory framework, whether we call this hemp or marijuana, there's going to be about 20 federal agencies that come into play. You know, we anticipate like TTB, a Tax and Tariff Bureau, which handles adult use, alcohol products, will probably handle intoxicating THC or adult use THC products. And so we're just here to say the federal government is doing very specific things. President Trump is taking very specific
All your
actions.
time has expired. I'll give you a couple seconds to wrap up.
Thank you. So let's just take that into account as we contemplate how the state of Missouri should respond. And that's all I got.
Thank you for your testimony today. Any questions? Seeing none. Any others for informational purposes? Seeing none. Closing remarks.
Thank you, Mr. Chairman. Just a couple of comments. One, on the hemp side and putting rules and regulations in place, I worked on that for 10 and a half months last year, trying to put that framework in place. I worked directly with the Missouri Hemp Association and a lot of hemp businesses and farmers throughout the state. And after 10 and a half months, I could not get to a consensus among those folks alone, not bringing in drinks, not bringing in anything else, to come up with a regulatory framework. Everyone wanted something different. It was impossible to try to come up with that framework. So we did really try to do that. And again, the federal government has stepped in and said, as of November 12th of this year, they will not be legal. So I don't see a real need to try to put that framework in place for a few-month period between when a bill is signed here in Missouri and when that federal action takes place. Thank you for your time today.
Thank you, Representative. That'll conclude the public hearing on that House bill. And having no other further business for the committee, I make a motion that we adjourn.
I can record your vote. Second.
All right, we are adjourned.